let me just say this. I don't care if somebody's on the defense side. I don't care if somebody's on the prosecution side. It doesn't matter to me, especially between counts. No one is ever going to come into this courtroom and be intimidated in some way by some threat to their profession, particularly in proceeding with what is their obligation. It is Ms. Hughes's obligation to bring this case. It is your obligation to defend your client. She can't make threats to you to try to prevent you from proceeding to defend your client or to do nothing if your client wishes that for you to do that as the defendant. This behavior, Mr. Bennett, is inexcusable in this court's mind. Absolutely inexcusable. And quite frankly, sanctionable. Because you can't try to make somebody not do something, but no one is ever going to come into this courtroom and be intimidated in some way by some threat to their profession. Okay. Court does call the case of the people of the state of Michigan versus James Witt.
On behalf of the people.
Good afternoon, Your Honor. For the record, my name is Jeffrey Benn. I'm standing with on behalf of Mr. Whitley, James Whitley.
Thank you. All right.
Counsel and I have.
Yes, you may.
Thank you.
The 14th District Court for County of State of Michigan is now back in session. The Honorable Judge 77 was up.
You may be seated. Back on the record in the case of people of the state of Michigan versus James Whitley. Typically, oh, go ahead.
Thank you. No full use on behalf of the people.
Good afternoon, Your Honor. For the record, my name is Jeffrey Benn. I'm here with on behalf of Mr. Whitley, sitting to my right.
Typically, the court doesn't publicly discuss, and I will apologize, Ms. Hughes, and I will allow certainly counsel to say what they want to say or need to say. The court doesn't discuss bench conferences, but I think under these circumstances, I'm going to certainly disclose that unless Ms. Hughes, since it was your issue that you brought to the court, unless you have some strong objection to that.
I have no objection. Thank you.
The court has been informed that, at least alleged, that the defense counsel has indicated that should this exam begin, that it may be his intent to grieve the elected prosecutor for pursuing this case. Court has some concerns with that. First and foremost, that posture in and of itself can have a chilling effect, not only on just proceedings and may be an attempt to interfere in these proceedings, which may in and of itself constitute a grievable offense, but also that this court, if that is indeed the allegation, would not proceed with a hearing that would require someone to then commit a grievable offense. And Ms. Hughes also disclosed to the court that she, in essence, went up her chain of command to seek their advice as to what she should do. It was ultimately said, I think, at one point to certainly bring it to the court's attention, which I think is appropriate since it's under. Mr. Bennett, I will ask you whether or not you believe, in this case, that the people in proceeding are committing a grievable offense. And if so, for you to state on the record what that offense is.
My concern,
I'm not asking for your concern. I'm asking for, you have made an accusation that, know what?
I don't believe that they're committing a grievable offense.
Do you believe that in starting this exam, that they would be committing a grievable offense?
No,
Was that said to the prosecutor?
that was said, I don't believe it was said in the manner that was described at the bench, but certainly
Then tell me how it was said.
well, there were two things. One, at the bench, do you want me to ignore the one you didn't disclose?
Tell me how it was said.
What I said is that I believe that if the state were to go forward, that it would be grievable because I believe that the prosecutor is not following through on their ethical obligations under the Michigan Rules of Professional Conduct.
Which ethical obligation are they not following for?
The two that I am concerned about are, one is determining what the actual facts are, and the two is prosecuting somebody who may in fact be actually innocent. What I did was I had offered Ms. Hughes, if she felt that it was appropriate, if she wanted to discuss the recanted note with the alleged victim, I said, why we could just adjourn this out and you can talk to her and decide how to go forward. So my only concern is that they didn't make contact with the alleged victim, who now has a different story, but I no longer believe that's a problem.
Is that, even as you describe it, amount to something that is grievable?
It doesn't. But
And why was it said?
because at the time I believed that it was grievous.
What changed?
Quite honestly, what changed is I wasn't aware at the time that they had the lay witness here. And so the presence of the lay witnesses, I think, eliminates all of the issues I had with the police providing the testimony that's admissible here, but not in trial.
Ms. Hughes.
I absolutely intend on proceeding pursuant to MCL 76827C. I have made no statements to Mr. Bennett about Ms. Potter being present. But I don't think it is, because Ms. Potter is not present.
Explain to me, Mr. Bennett, how that makes a difference. Because quite frankly, I think your accusation is against the prosecutor amounts to your attempt to obstruct these proceedings. So explain to me, which in and of itself would be grievable, counsel. So explain to me what happened now that you know that they're there, how that changed the whole mindset.
The proceeding with statements that would exclusively be inadmissible at trial and going forward on those. These are confrontation clause issues.
There's a statute which covers that.
I understand that, Your Honor. My concern was it goes to circuit court on those statements, and now they can't proceed to trial. Because at that point, confrontation is going to attach at trial.
So why would that be grievable? If they proceed pursuant to a statute promulgated in the state, as well as a court rule, which covers that. Why would that be grievable at any point?
My concern was not determining the facts of the case that they're going to present evidence in today.
If they believe those facts that, but for a hearsay objection would come in, that not at all goes to their determination of the facts. They may believe that to be the case.
I understand.
So how would that even come into play? Mr. Bennett, how does that even come into play?
I explained what my position is. I don't know what else to say.
Okay. Quite frankly, as I'm listening to your explanation, are just absolutely unequivocally false threats to their livelihood.
I don't believe that's what I was doing.
What do you think you were doing?
Trying to bring to Ms. Hughes' attention an issue that may or may not exist. She interpreted it as a threat, which I understand.
I'm going to grieve your boss. And you.
I did not.
If you start this exam. She's supposed to take that as something that should be brought to her attention as opposed to a threat?
We continued our discussion a second time where I was explaining where I was coming from. I did not say what I said in a very artful way. So
You threatened a grievance for her proceeding. Am I wrong in that?
I didn't consider that I threatened it. I was trying to bring an issue forward. She took this threat.
She took it as a threat. What was she supposed to take it as?
She took it how she took it. I mean, it was a mistake on my part. I acknowledge that.
You're trying to tell this court that you didn't intend to threaten her boss and ultimately her? Is that what you're telling me, Mr. Bennett?
I was trying to bring the nature of what I saw as a potential issue. I unfortunately started it.
The issue being what? Their use of evidence pursuant to the court rule, which is why we have these hearings, why you have the ability to object, and then this court would have to rule?
I felt this case was different because this is not a situation where, this is a situation where the alleged victim is given another detailed statement as to what happened.
And so what makes that different?
The duty to investigate the facts.
How do you know they haven't?
Besides her telling me that they haven't, I don't know.
I don't know who the per is, but I've never told him the information. I've never told him about the many contacts that she's had with my office. I've never told him about, he's put on the record that she's been appearing at the hearings. Your Honor, she's been at hearings that Your Honor has presided over. The letter that was turned over to the police department was then turned over to the defense. And frankly, he has never asked me. He just came forward with, I'm going to grieve Ellie Sabat.
Mr. Bennett, I am very concerned. What was your intent on saying that?
I intend in this.
You know, I'm going to stop you right now because I'm going to tell you something. You need to be real careful because I may have to consider grieving you.
I understand that, Your Honor.
And I don't think you want that.
I certainly don't want that.
So what I'm going to do is I'm going to take another about 10-minute break. And I'm going to come out and ask for your explanation before I decide on anything that I would do. But I will let you know, Mr. Bennett, with regard to what I've heard of the conduct here, you are walking on real thin ice, not just with me, but with your ticket to practice. Court's in recess.
All rise. The District Court for County of Washtenaw, State of Michigan is now back in session. The hour is 7:50.
May be seated. Back on the record in the case of the people, State of Michigan versus Whitley, counsel is present as well as the defendant. Is there anything else regarding this issue that either side would like to say?
Your Honor, I'm going to self-report the violation under Michigan Rule of Professional Conduct, 8.3 subsection A. I agree that I gave the inappropriate message to the prosecutor. I apologize for doing that. I feel obligated to report myself.
We will see if that happens because the court hasn't made a decision as to whether or not the court should report you. Mr. Bennett, I am going to tell you in all the years I've been here, counsel, and even when I was down in the trenches, counsels say things to each other, maybe not meaningful necessarily. They'll say things out of anger to each other. I don't know why you would even think it would be within the bounds of anything decent to make that kind of threat. And I call it a threat. That's precisely what you were doing. And I have to make a decision now knowing it as to whether or not I should do it. And I will make that decision. Ms. Hughes, and I'm going to apologize on behalf of the court for having to do this, but I think it's necessary given this turn of events. Would your lay witness, as well as I guess the officers, would they be available on July 1st at 10?
Is it at all possible to have the lay witness testify? It would be to identification. And I would.
As to identification of
The defendant. So it's very brief. And I don't want to have to bring the lay person back.
understand. Mr. Bennett,
I would stipulate to the identification.
So you're stipulating that the person that is sitting beside you is James Whitley and that he was in a relationship with Jennifer Potter on April 27th, 2024.
Yes.
Thank you.
will that satisfy what that witness would testify to?
Yes.
Very good. Thank you.
What was the date? I apologize.
I am going to adjourn this, if it will work for everybody, to July 1st at 10 a.m. That is my only.
July 1st at 10 a.m.
I realize that gets close to a holiday, but will that work for?
Yes. Thank you.
Oh, that's fine. I will adjourn it. Mr. Bennett, please apprise this office as well as apprise the prosecutor if you're going to self-report so that maybe others of us don't have to take any action.
Yes, Your Honor.
Preliminary examination in this matter is adjourned. July 1st, 2024, 10 a.m. before me. Thank you. That's exactly what they said.
They did not, Your Honor. They said that he knew where we moved.
Mr. Alice. Court does call the case of James Samanek versus Travis Ackerman and Nikki Meltzer. Counsel, state your appearance.
For the record, Tom Nellis appearing on behalf of the plaintiff and president of the Honor.
Your names?
Travis Ackerman.
All right. You folks tried to resolve this matter or no? We're just gonna go to trial. Pardon?
We attempted this weekend. I'm gonna do that until resolution.
How close were the parties before we go into this?
Not very close, sir.
Mr. Ellis, you'd agree with that?
Yes, Your Honor, the defendants do not feel that they owe any money.
On this matter, then, this is the date and time set for trial on the Seminole matter. You ready to proceed?
Yes, Your Honor.
All right. Go ahead.
Your Honor, we have filed a motion to amend our complaint to include a complaint for damages and, I received no response from the defendant.
When was the motion filed?
You can go yesterday.
You guys get a copy?
It was addressed on May 21st.
I don't see a copy of a motion.
I can approach the bench and give a copy.
Do you see it in our thing that it was filed? You do? Yeah.
I have a note on May 20th, plaintiff submitted the motion to amend. It may have been filed in Saline. When did you reach out to obtain a copy?
Hmm?
Do you need me to reach out to obtain a copy?
I've got one in front of me. When did you guys get a copy of this?
It was dated May 21st, 2024.
Say a few days
A
after
few
that.
days after that,
In what?
just before heading into Memorial Day weekend.
21st?
Yeah, this was dated May 21st.
For what date did you, the postmark? What is that?
Postmark on May 21st, right here. It's the date that it was sent out.
So this is raising issues that they're entitled to answer regarding the security deposit.
Well, the lease provides that the security.
It doesn't matter what the lease is. I'm talking procedurally. You're raising claims regarding the security deposit at this late stage.
Well, they didn't leave a forwarding address, Your Honor.
Well, but that would precisely my point. They would be in, you haven't alleged that they haven't in this alleged amended complaint. You're just alleging a claim against the security deposit. Because I think as we were here at the last hearing, when we were talking briefly about it, they had indicated that they had provided a forwarding address.
I do not believe that's what they said. I believe
That is exactly what, is that what you said?
Yes, sir.
Your Honor,
No, I don't, just answer my question.
yes, yes, Your Honor.
That's exactly what they said.
they did not, Your Honor. They said that he knew where we moved.
Mr. Alice, they said it the last time. I just said it. I asked them to verify that my recollection of what they said is correct. If you have a dispute regarding the facts, fine. But if you're telling me that my recollection is incorrect, you're wrong. They said it. You may disagree. That's fine, but that's an element of any claim against a security deposit, which is precisely what I'm saying. Procedurally, this is a problem. They're entitled to answer, first of all, the motion to amend, and this is the procedural route. They're entitled to answer the motion to amend. They haven't been provided. Was this mailed to them?
Yes.
You know, under the court rules, that's not enough time. You can't mail it. Says on the 17th. They don't get it till then, so they're entitled to answer the motion, and then they'd be entitled to answer the complaint if I were to allow them it to proceed. Folks, do you know what you want to do on the motion?
Sure, I answered that, sir.
That was an unfair question. Folks, do me a favor. Can you look at that amended complaint for me? And look at paragraph 3. You see it, the numbers that are there? All right. Without telling me why, because you don't, I'm not sure what I'm going to do with this yet. Are you disputing the electricity?
It's the electricity.
The electricity amount?
We had no recollection of that electricity until the last hearing. So we had no opportunity to even pay Mr. Stemmett back for that.
Okay, but
We won't
let me,
I don't have any problem with that.
pardon?
I have no problem disputing that. That's fine.
You have no problem disputing it, or you
Not
have no problem with that amount? Okay,
every year.
that's fine. That's fine. The $2,400 in rent, are you disputing that?
Yes.
The propane, which we talked about, is obviously in dispute. And as I recall, at the end of the hearing, you're disputing the paint damage. Mr. Ellis, why should I allow this amendment at this late date?
Pardon me, Your Honor?
Why should I allow this amended complaint? Because it raises new claims.
Well, I thought since they did not answer the complaint, we have the absolute right to file an amended complaint without leave of the court. And they never answered the complaint.
So landlord tenant proceeding, they can answer orally. Jeez, oh Pete. Know the procedure before we walk in, counsel. Court's gonna stand in recess. Sir, did you have a problem hearing?
Yes.
We have equipment that I'll have my staff provide to you so that you can hear the proceedings. Thank you.
All rise.
Court recalls the case of Samanek versus Okerman and Meltzer. All right. Couple of things here. First thing is the motion filed before the court. Usually leave is freely given to amend. This motion, the court could consider to be an untimely filing of the motion to amend the complaint, mainly because it doesn't. It changes the claims and makes a claim against the security deposit. There are certainly disputes, I guess, as to whether or not the Security Deposit Act has been complied with. Now, what that means, since you are operating in pro per, I would just indicate if it hasn't been complied with and wrongfully withheld, you could, under the Security Deposit Act, be entitled to double damages. That is one of the penalties under that act. Not saying that that's the case here, but it is certainly something that is within the realm of possibility. And that, quite frankly, would have been there absent the complaint, absent this motion to amend or the first amended complaint. So there's that. To try to get this matter resolved, and the court really is of two minds. One, given the timing of this and the setting for trial, I almost don't want to permit the amendment of the complaint. However, what would in effect happen is, in this court's mind, litigation regarding it would happen in any event, whether initiated from the defendants or whether initiated from the plaintiff. So my thought is to just get everything here and try to resolve it. however it gets resolved through trial. Having said that, the other problem then arises. So for you guys, that would be that unless you're objecting to the motion itself, you're then entitled to answer, which I would grant the motion. So let me make it easy. All right. So you don't spend your time with that. Then you're entitled to file an answer regarding the complaint. Okay. And basically it's an admit or denial or put forth your position regarding each of the allegations that's in this complaint. Now, having said that, the problem with the complaint as presented to the court is that the complaint would not survive a C8 motion. And that motion, frankly, on the face of the complaint, because it involves the Security Deposit Act, doesn't state the necessary claims regarding the Security Deposit Act. And I know I'm talking in legalese and I'm trying not to, okay? A C8 motion basically says that on the face of the complaint, just looking at the complaint, that the complaint fails to state a claim upon which relief can be granted. The remedy for that is not dismissal necessarily of the complaint out of the gate. It is to permit amendment of the complaint. All right, got it so far? When a claim is made against the Security Deposit Act, there are certain, as I've indicated, certain requirements. Certain of those requirements must be pled, except to some very specific limitations within that act. So what I'm going to order is this. And folks, if you don't understand anything that I'm saying, just because this is an awkward posture for this case to be in, but just go ahead and ask me and I'll answer it. I'm allowing the complaint to be amended, but I'm directing that plaintiff must file a proper complaint that would, at least on its face, withstand a C8 motion and properly state a claim upon which relief could be granted under the Security Deposit Act. Plaintiff is to do that within 10 days. Defendant then has, I'm going to require a written answer this time. Defendant to file a written answer to the complaint within 10 days after receipt. Okay. So I need an amended complaint from the plaintiff 10 days out. Once you receive it, even if that 10 days hasn't expired, you need to answer within 10 days of receipt. Then adjourn the non-jury trial to, on the way out the last time, my understanding is there are nuptials that are to be occurring. So non-jury trial, June 18th, 9 a.m. Okay. And then we'll proceed at that point, have your witnesses, have your exhibits, have everything available on the 18th. We're just going to try to plow through as much as we can. All right. Any questions from either side?
No, Your Honor.
All right. And Mr. Semenek, did that help you? Okay. So next time when you come in, just ask for it and we'll make sure you get it. Okay. Thank you. All right. That does it.